Good morning.
Hi, good morning. Hi. Ladies first, who are you checking in on?
My name is Alexis Cardoza, and I have a 9:30 hearing.
Okay, and there's a second plaintiff, David Knapp. Is he joining us today?
He is.
Okay, stand by. Okay. Do you need this or is this for me?
I don't need that, that's me. We gotta give them a spoon.
Sorry?
Sorry.
Okay, stand by, ma'am. Okay, we got you checked in. We're just waiting for the other party to check in. Oh, hang on, somebody else is checking in. We're just waiting for all of our parties to check in. You and Michael Vaughn are our first people to check in. Oh, actually, hang on, Michael Vaughn?
Yes, I'm here.
Okay, great. If you would please, you can turn on your video, then that way it might make it a little easier to get around. Okay, we have both of you here. Ms. Cardoza, are we waiting for Mr. Knapp to appear?
I'm here.
Oh, hi. Oh, thank you, everybody. So it's Madeline and Oliver?
It's our kids' Zoom school call-in name. Sorry about that.
Okay, no, that's fine. So Madeline, so those two names, is that correct?
Correct. That's David Knapp.
Okay, no, that's fine. No, we're just gonna rename it so that we have so we know who all this is in the room. That's all. Okay, so we've got. Okay, wait a minute. Maybe I misnamed them. Hang on. Okay, gentleman with the skull cap on, are you Mr. Knapp?
Yes.
Okay, got it. And okay, I see Mr. Vaughn. Thank you very much for joining us. Okay, it looks like we have everybody here for this case. Okay, this is with regard to case number 20240645. Parties on Alexis Cardoza and David Knapp plaintiffs and defendant Michael Vaughn, DBA Vaughn's Plumbing LLC. We've got everybody here. Here's what we're going to do procedurally, and it's a little, with small claims cases, here's what we're going to do. The plaintiffs have the burden of proof. We're going to swear in everyone in just a moment. The plaintiffs has the burden of proof, so the plaintiff will present testimony first, and then the defendant will have an opportunity to respond. While the testimony is ongoing, please allow each side to present testimony uninterrupted. So the plaintiffs will go first. If anyone or either party has a question or a point that they wish to address, please hang on to that thought until your opportunity to be heard, and we promise everybody gets an opportunity to be heard. And again, we're going to take turns. And plaintiff has the burden of proof. Plaintiff goes first. Also, if it is the case, and this is actually one of our first cases of the year, if any parties have paperwork or any documents to present, it is the case. Now we're doing everything electronically, including Zoom. So if you have any documents or paperwork to present, be advised that the other side is entitled to review those documents. Back when we used to have hearings in person, we would have an actual exchange of documents and paperwork actually in person while people were present. If it is the case that anyone is presenting documents or materials today, it would be a little bit different if that is going to happen. The likelihood is high we would simply adjourn this until this time next week to allow parties to send in electronically their documents and paperwork, and then the court would do its best to try to forward one another's documents and paperwork to the other party, because again, civil rules of evidence still apply, so the parties are still entitled to review their documents. So we can work around that as best as possible if everyone wants to simply proceed today. But again, if anyone wants to review any documents and materials, then it would be the case that we would probably have to adjourn this to allow everyone to submit their documents electronically. Our website has the capacity to submit documents electronically, and then we forward it to all the parties who are interested. So we'll address that as we get there. So I guess the first question is, Ms. Cardoza and Mr. Knapp, do you have any documents or materials that you would be presenting today or at any time during your testimony?
Well, let me ask you this. We submitted our documents with our with our initial documentation. So that was distributed by mail, and these would be the only ones that we would present.
Okay, so let me ask you, okay, so let's take a look. Okay, court is going through here, and it is going to be, what we're looking at is Vaughn's Plumbing LLC complaint summary timeline. Was that, okay, submitted
Correct.
by, got that, so that's from you. So the next question is, Mr. Vaughn, did you receive a copy of that document before today's date?
Are you saying, did I receive the notice to appear?
No. The question is, sir, Ms. Cardoza and Mr. Napper or Ms. Cardoza has indicated that she sent, at least to the court, a timeline of events.
Oh, no, I haven't received anything like that.
Okay, all right, stand by. All right.
Wouldn't that have been included in his documentation that he received from the court?
Well, that's the thing. Again, in light of COVID and the Zoom hearings, where the court is trying to discern exactly what everyone received. So if it is the case, Ms. Cardoza, that you submitted it to the court, that's why the court is looking to confirm with Mr. Vaughn that he did in fact receive that paperwork. So that's what we're just trying to discern, because if you submitted it to the court, it did make it to the file. So the answer is yes, it did make it to the file. But the court is also asking of Mr. Vaughn whether he received a copy of that as well. So stand by.
No,
so you're saying you did not receive that?
No.
Okay. Stand by. Okay. So Ms. Cardoza, it appears that this is a timeline that you typed up and provided as part of your filing. Is that correct?
Correct.
Okay. All right. Here's what we're going to do. We're going to swear everybody in. We're going to start to take testimony. We're going to see how far we get. Now, essentially, Ms. Cardoza, it appears then that what you submitted as far as this timeline is simply a summary of what you will be presenting today. Is that correct in testimony?
Correct. There's that. And then I had one piece of evidence. I guess it's the check that Michael Vaughn cashed to bars.
Okay. Okay. It is, okay, with the court is review. So that's the only other, so aside from the summary, your document with regard that shows the front and back of the check is what you will be submitting today. Is that correct?
Correct.
Okay. Okay, Mr. Vaughn, back to you, sir. Again, before we start getting into testimony, because the court mainly right now is trying to get an overview of exactly how far we can get. It appears that if that is the only thing that Cardoza and the NAP parties are submitting, then it may not be an issue today. So, Mr. Vaughn, okay, here's what we're going to do. Parties, raise your right hands for me. Do you swear or affirm the testimony about to give will be the truth?
Yes.
Okay.
Yeah.
Stand by. We have one other party that we're checking in on another matter. Stand by, please. Okay, it looks like we have someone from Community Business Consulting joining us. Hi, sir. Your name? Hi, sir. We need to be able to hear you. For Community Business Consulting, sir, your name? Hi, sir, from Community Business Consulting, can you hear us? Hi, gentlemen from Community Business Consulting, can you hear us, sir?
Yes, I can hear you. Can you hear me?
Yes, we can hear you now, sir. Your name, sir?
My name is Paris Boyce.
Okay, and we do have a number of matters here for you. We have one case ahead of you, so just sit tight. We're also going to wait and see whether or not any of your parties appear, okay? So we got you checked in, okay?
That's fine.
Okay, thank you. And if you would please, just until your matter is called, just kind of keep your ear open, but put yourself on mute because we're going to be taking testimony on another case at this time.
Yes, Your Honor.
Thank you, sir. Okay. All right, Ms. Cardoza and Mr. Knapp, we've got everyone sworn in on this case, and Mr. Vaughn. Mr. Vaughn, we're going to be taking testimony shortly, so the only thing left, it appears, is that the plaintiffs have submitted is a check.
We also provided some telephone documentation, but it's really just, the check is the most important piece of evidence.
Okay, well, let's start with that. Mr. Vaughn, the only other thing that the plaintiffs have submitted that relates to the cause of action is a check made out to Vaughn's Plumbing. So we're going to get to that in just a moment. And if that's an issue, then that will just help us determine whether or not, how far we're going to be able to get into the testimony. We're going to get started and start taking testimony. Okay, starting with Mr. Cardoza and Mr. Knapp, what's going to look at this. It is based on a review of the file, the cause of action arises from cause of action was from March of 2019. You're suing for $5,999, indicating that on or about March 19, Mr. Vaughn or his company was hired to perform 2 water taps and paid $6,500 on March of 2019, and then on August of 2019, Mr. Vaughn was paid for 2 water tap permits totaling $1,320, and then in August of 2019 through May of 2020, the plaintiffs were reaching out to Mr. Vaughn to perform the work, and the work wasn't completed. Then on May of 2020, Mr. Vaughn agreed to transfer the permits to a new customer and refunded $2,000. Looks like a total of $6,500 got paid. So with, looks like some adjustments with regard to what, if any, work was done and any agreed to adjustments between the parties, the plaintiffs are now claiming $5,999 owed with regard to this project. So that's this court's just review. I mean, it's a bit abbreviated, but that seems to be an overview of what happened. So it appears that there was a contract for services, and also which you plaintiffs have submitted was a check for $6,500 made out to Vaughn's Plumbing. The court does review that, and it looks like on the back side it is written, printed out for deposit only. So let's just start off. Mr. Vaughn, do you acknowledge that your company that Vaughn's Plumbing did receive a check from the plaintiffs in the amount of $6,500?
Yeah, sure did.
Okay, you did make that deposit.
Can I say this? I don't have a problem with, yeah, we did cash the check. I would like to see the summary that you have. I don't necessarily need to see the check.
Okay, well, here's the thing. What we can do is we probably have to submit this back to the civil division and see whether or not if it's available. If it's already available, perhaps as an attachment, then perhaps we can expedite this and send it to you. Tell you what. What's her number here?
03965-2567. 2567.
Okay. Okay, here's what we're going to do. One, we want to make sure that everybody is present, but also be advised that in order for this court, in light of Zoom, to comply with the Open Meetings Act, court is always open to the public. We are live streaming, so there are some occasions where this court may ask you to call the courtroom because, again, we want to try to keep everyone's information private, like telephone numbers, addresses, email addresses. So here's what we're going to do. Mr. Vaughn, if you would take down this telephone number and give our court a call, we want you to provide us with an email address.
Okay. 313-965-2567. And that'll bring you into our courtroom. Please provide us with an email address, and we're going to keep taking testimony and get as far as we can. But be advised, Mr. Vaughn, that the likelihood is high that the summary is not in itself evidence. Basically, it's just written, it's in written form what presumably the plaintiffs are going to be presenting in testimony, okay?
Okay.
So by itself, it is not evidence, it's not a part of the contract for services. It's simply, and like the court was asking ahead of time, what it is that they present, that they put in with their filing is simply a written summary of what's going to be presented in testimony today or at any time, okay?
Okay.
So it's not evidence. So if anything, the goal would be for everybody to be present and to be able to hear what everyone else is going to be presenting. So it's not like you're going to be excluded from anything, okay? Further, be advised, and this is for everyone in the case, the summary again is not evidence. It's simply in written form what's going to be presented in testimony, and the court only takes what is presented in testimony. So even if there was something in the summary that perhaps doesn't come out in testimony, the court is not considering that over and above or giving it a higher priority just because it's in writing, okay? So just be advised that it's as if we're all giving testimony, okay?
Okay. Well, that being the case, then I don't have a problem with moving forward right now.
Okay, that's fine. Thank you, everyone. Okay, but again, just hang on to that. So if it comes up, then, we'll address that. So here's what we're going to do. Okay, Ms. Cardoza, now that we've kind of gotten some of the housekeeping out of the way, either yourself or Mr. Knapp want to start to present testimony.
Okay. Would it help if I shared the summary timeline as a screen share and essentially verbally dictate it?
That's fine, Mr. Vaughn. Mr. Vaughn, I think that will help because in that way you'll see the same thing that's been presented, okay? And again, everyone be advised that it is not evidence, it's simply a written version of what's going to be presented in testimony, okay? So yes, thank you very much, we appreciate that.
It looks like, do you mind allowing screen sharing with me?
Let's take a look. Okay, you guys are really pushing the limits of this court's ability to work with Zoom, so give me a second.
Okay, thank you.
Okay, I see share screen. I'm seeing I'm seeing basic, advanced, and files. No, that's not it.
Oh.
Hang on.
If it's too big of an issue, I could just read it verbatim.
Okay. Go ahead, ma'am.
Okay. I guess firstly, on March 19th, 2019, Michael Vaughn came out and provided us with a quote to provide 2 new domestic water taps and directionally bore to those water lines back to our new construction project. He quoted us a total of $13,000 to perform this work on March 12th. On March 26th, we accepted his offer and paid him a down payment equaling 50% of that $13,000. So a check for $6,500 was written to him, which he cashed the next day. I state in full disclosure, in early 19, we experienced a roadblock in gaining permits with DWSD. The problem was resolved within approximately a month's time, we'll say by May 1st. This delay was not caused by Michael Vaughn. It was an owner related issue. But once this was wrapped up, there was no reason that Michael or Vaughn's Plumbing could not start the work at that time. So from May 2019 to August 2019, we pleaded with Michael to come out and perform the work. We bought this, we're paying for this out of pocket, as $6,500 is a lot of money to us. We couldn't afford being out of pocket. So we really needed to work with him to have the work performed.
Not to interrupt your narrative, ma'am, let me ask you this, was this a commercial or like a personal residential, or what type of property was this, your project?
Residential.
Okay, go ahead.
So running out of options, we tried taking as many variables to help him out of his control. Like we set up an excavator and a flat work contractor that he could resource, because he was using the excuse that his contractors weren't available. So we tried connecting him with contractors we had relationships, and we even offered him the opportunity to back out and refund our money. And he declined our help, and he declined to return our money at that time. We basically contacted him every day, every other day, to motivate him to come out and perform the work. Sometime in August 2019, we believe he formally pulled the DWSD permits. And this is about 3 months after he was first able to pull the permits. DWSD, they were unwilling to give me all of the information because I wasn't the one pulling the permits. So that's about the extent, is that we know that permits were pulled in August 2019. And I just want to make a note that by Vaughn's Plumbing pulling those water tap permits, he essentially held our water tap work hostage, for lack of a better word, because we were unable to do this work with any other vendor, because you can't have 2 permits open at the same time. So he really was the only person that was allowed to do this work at the time, because he's the one that had the permits pulled in his name. So the permitting costs, from what DWSD told me, that there was we had two taps totaling $1,320. Let's see here. We could not, again, and then not only was he holding those permits hostage, we couldn't afford to close out those permits and pay someone else another $1,300 to reopen them. Let's see here. So in August 2019 through November 2019, again, we pleaded with Michael Vaughn to perform the work, and he gave us every excuse on why he couldn't. And the water tap was the basis of the critical path, the construction's critical path of our project. So from, let's see, May 1st to the end of 2019, Michael Vaughn held up our construction project. So we lost a lot of money in paying premiums for other contractors, years down the road. We were paying insurances on this. We were paying to protect it, to secure the building. So again, we pleaded with him to perform the work. We could not move forward with our construction until this work was performed. A couple notes. On September 12th, 2019, he told us that he'd work with our excavator, finally, under his own payment arrangement and not us pay for it directly. And he would start the work on Monday, September 16th, with our excavator to finally do the work. He waited until 7 a.m. of that morning to text us that he wasn't going to start the work and that his directional boring machine was down. There was plenty of work to be done prior to the directional boring, and this was just another unjustified excuse. And then he went radio silent, for lack of a better word, both via text message and phone for 2 weeks. We were finally able to make voice contact. On September 20th, when he said that he could not come out to do the work with our excavator.
I'm sorry to interrupt you again, I'm sorry, but just as to that bullet point, you're saying on September 20th, when he said that he could come out to do the work.
Oh, yes, I apologize. Thank you. So on September 20th, when he said that he could come out and do the work with our excavator on September 24th, they had already coordinated that. That's how soon they could come back out. So then later that day, we sent a text message saying that in the event that his boring machine was still broken, he could just open dig that work. So we wouldn't cause any more delays. So there was no excuse. So then he essentially saying we essentially said he had no excuse not to come out and do his part of the work. And he responded, LOL, I appreciate your help, but please stay in your lane. Mind you, we're just trying to help him. On September 24th, 2019, it lightly sprinkled all day, and they did not show up and they did not give us any sort of alternate schedule.
Let me ask you this, again, just to clarify, on September 24th, were you able to make contact with Mr. Vaughn about what, if any, work would get done on the 24th?
He was supposed to show up on the 24th, and he used an excuse as a rain delay.
So you did, okay, so on the 24th, either yourself or Mr. Knapp did make contact with Mr. Vaughn on that day, but ultimately the response was, there's a rain delay?
Yes, it was a rain delay, and he gave us no alternate schedule.
Okay, that's fine, go ahead.
Okay, so from November 2019 through January 2020, no work could be performed for weather. It was raining, it was cold, but we continued to try to get reimbursed for the $5,180 that he still owed us at the time if he wasn't going to perform the work. Finally, Michael Vaughn conceded and agreed to reimburse us in increments.
Okay, and again, I'm sorry, again, just to clarify, meaning reimburse in increments for the entire $6,500 or for some work, or what? I mean, just elaborate.
Yeah, so so that $6,500, he did pay for permits. So we were just trying to get reimbursed for the balance of, so the $6,500 minus the cost of permits.
Okay.
Assuming those permits would get us work in the future, or
yeah, and yeah, that was under the assumption that those permits were transferable.
Okay, all right, no, that's okay. No, thank you. It's okay.
So on January 27th, Michael Vaughn did provide us a $2,000 repayment installment. So from January to May, out of respect of the COVID, the difficulties we were all facing in COVID, we sort of left sleeping dogs lie. We didn't bug them. We were in a tight spot. We suspected he was probably in a tighter spot because of the economy and probably the work that he wasn't able to do during that shelter in place. But we did try. However, in turn, Michael Vaughn did not try to reach out to us at any time to inform us of his intention to reimburse us the remainder. In May 2020, we were finally able to find a new contractor to perform the work within a reasonable price. After 12 to 13 months of pleading with Michael Vaughn, he agreed to transfer the permits to our new contractor and have this new contractor perform the work under his license. We paid our new contractor a total of $16,200 to perform this work. And this is a $3,200 premium to what Michael Vaughn initially quoted almost a year prior. So this contractor did successfully complete the work, and we have a fully unconditional waiver stating that this vendor was paid in full. So from March 2020 to September 2020, we continued to correspond with Michael to get the remainder of our money returned. Again, he continued to give us excuses why he could not repay us, which brings us today. So I just want to make note of the lost revenue. So not only did he not repay us the money that he, in my mind, stole from us because he performed zero work, he also caused us substantial delays. He delayed the project by, this is conservatively 6 to 10 months. I would argue it's more, but we'll give him the benefit of the doubt. Michael Vaughn's pride and inept caused serious financial repercussions for us as homeowners. We have been paying 2 mortgages throughout this entire time with no ability to generate income. And we sat and watched a stalled construction project that was 100% the fault of Michael Vaughn. As I mentioned prior, the water tap was critical path of our project because we couldn't get the water tap in, we couldn't put the slab down on the first floor, we couldn't build stairs to the second floor. So I can't explain to you the delays that he caused for us. So the reality is, although we're asking for $5,999 in total claims, he really cost us probably about $15,000 to $16,000 in lost revenue. But
Just through this then, and again, not to interrupt your narrative, but here's the thing. Small claims, again, you're limited with regard to certain dollar amounts, which is what's happening here with regard to the amount of your claim. But if it is the case that you have concerns about, or even potential future losses or anything like that, there is the general civil division, and this could be removed to the general civil division. That way, if there are larger claims or anything over and above just the actual contract price or what it is that you're claiming here, that does open the door. Because here's the thing. I mean, we're going to be taking testimony from Mr. Vaughn as well, but when it's all said and done, in the event that you as the plaintiffs prevail in any way, shape, or form, that's pretty much it. You can't come back and say, oh, by the way, we just found out that, we've got more delays or XYZ has happened. You don't get a second bite at the apple. So it's just
that's understood.
If based on what you're presenting. So that's the court. Before we go any further, that's just one thought, one seed to plant, and then that way both sides would be in a position, like I said, to be able to address everything in full at one time in one cause of action.
Understood. I recognize this could have gone up to another court, but really we just want, which takes me to the summary of claims. So I sort of show us the math and how I derive to my claim. So we paid him the $6,500. He paid for 2 water taps and he reimbursed us $2,000. Our court fees that we filed were $81. And I'd like him to pay for the premium that we paid to our new contractor. So that takes us to what we're asking Michael Vaughn to reimburse us is $5,999.
So essentially the agreed upon repayment price, you already paid $2,000, and that's what's left over, and then the over and above with regard to the new contractor. Is that
correct? And the court filing fee, which is minor.
Okay, well, just be advised, court fees that's a separate thing. So we kind of carved that out, set it aside, and that would be addressed further down the road. But essentially, the basis of the claim brings it to $5,999. Correct?
Correct.
Okay. Is there anything further at this
time? So with that, I've provided you the check that Michael Vaughn cashed on March 27th. And I know, well, Michael should have received this with the his notice to appear that we received in December, I believe. But it basically, it's a Verizon summary of all of the times we try to initiate correspondence with Michael Vaughn via text message and voice phone call.
Okay, thank you. Okay, Mr. Vaughn, we're going to turn it over to you, and we thank everyone in advance because again, Zoom kind of adds an additional layer just because of the tech issues that we're all living with at this time. So thank you, sir, for your patience. So Mr. Vaughn, that's the extent of the testimony from the plaintiffs. So we can start from the top, just a couple of questions to kind of launch us in that direction. You indicated early on before we did the swear everyone in that you did receive a check from the plaintiffs to pay out the Vaughn's Plumbing for $6,500. Is that correct?
Yes, that's correct.
Okay. And also, as a part of the narrative, the court appreciates the
the overview that ultimately you did pay back $2,000 prior to the filing of this action, correct?
Correct.
Okay, and go ahead, you can pick it up from there.
Okay, I guess as we start from the very beginning, when I was first contracted to do the job, apparently they had trouble, as she stated before, they had trouble with the water department. It was something that was done that the water department disagreed with. That held the project up for, as far as me getting permits for the job through the water department. That held the job up for until they got that straight. And if she said it was about a month or however long, I don't dispute that. After that got rectified, then what happened is we have to go and submit new drawings to the water department, get them to clear it. It takes X amount of days. I think it's roughly about, I don't know, maybe about a week for those drawings to get cleared. And
Was that the
then,
case here, sir? Was
I'm
that the
sorry.
case? Is that what happened here?
Yes,
So it took
down
about
at,
a week?
down at the water department. Once we
Okay.
submit, I'm sorry, go ahead.
Go ahead, go ahead.
Once we submit the application that we want to pull a permit, and then we do the drawing, then the water department have to take it to their people, and they have to go over everything and see that everything is in order, and then come back and give us the approval. At that particular time, there's roughly about a 5-day wait upon that. So after I submit the drawings unto them, then they approve everything, which takes like about 5 days. We give them about $1,300. Then we go up to the right-of-way people, which is in the Coleman A. Young building on the 7th floor, I believe it is. Then they look over everything, and their total was, it was two of them, 850. I think that total was like about 1,700. So both of those was paid. Both of those was, I'm sorry.
Okay, let me ask you, sir, the plaintiffs indicated $1,320. Is that accurate, or you're saying it was something other than that?
Yeah, that was one. That was for the water department. Now there's another set of permits need to be pulled by the right-of-way people. That was a total of $1,600.
And that was paid? You paid, your company paid that, or did that get paid?
No, we paid that. We paid that out of the 6,500.
Okay. Okay, go ahead, sir.
Okay, and now then after we paid that, we're all set, ready to do the work. The challenging thing is we have to dig in the street, let the city know a couple of days ahead of time when we're gonna dig, and we have to have that particular part of the street blocked off. So there's a lot of working pieces in place at that particular time. We have to get the boring guy, we have to get the trucks lined up. So when we pull out the old spoil, we have to put them in the truck, the dirt, the concrete, and then we have to bring new concrete or new dirt or sand in at that particular time. At this time, there's a lot of working pieces that we have to put into place. Now it's getting close to the winter time. It's not a whole lot that you can do inside of the winter time. So that's where the project kind of was drawn out some. At no particular time when she was calling me or her husband was calling me, did I ever dodge their call? Did I ever try to mislead them on anything? So I wasn't to the extent of trying to take any money from them whatsoever. When they called until they started calling me several times a day. And I even had a conversation with, I believe it was a husband, to where he was calling, and I really felt intimidated by the thing that he was saying, and it started getting me upset. And I stated to him, listen, with the thing that you're saying to me is making me upset, and it's going to go to a whole nother level. Yeah, you may be upset. I'm upset also with the thing that you're saying. At that particular moment, the conversation switched. He said, okay, I will not talk with you then. I'll let my wife start talking with you. I started talking with her. Again, you cannot do this work inside of the wintertime because.
Mr. Bond, let's just back up a little bit because the court appreciates that you're providing a timeline of what happened from the time that you're pulling the permits with the water department, and then you said that there's an agency that deals with right-of-way issues.
The right-of-way, yes.
Okay, the right-of-way issue, obtaining the right-of-way. The court's looking at the date that you received the check. You indicated that you submitted the check, or rather deposited the check, that the check, you received it end of March, it was deposited, you acknowledge it. So, and you also indicated in your timeline that it takes about 1 week to submit, once you submit paperwork to the water department, drawings to the water department has to approve it, that may take another 5 to 7 days. And then there's also an issue of the right of way. So this was basically getting into the spring of 2019. So what happened between the spring of 2019 and now you're saying you're jumping ahead to the winter? So what happened between the spring of 2019 and then when you're saying it got too cold? So presumably that's probably getting around maybe into October. Like let me ask you this. For your purposes, I'm just a lay person. So for you, from your contractor perspective, when is it getting too late into the season and winter setting in and is prohibiting digging from an industry for your perspective, from the contractor perspective? So spring of 2019, when does it get too cold to dig?
Yeah, I would say sometime around late October, early November. That's when the ground start getting real cold, and it's difficult to not just cut up the concrete, but then to pour it back also. Because again,
so let's address that time between spring of 2019 when the check was written around March 26th and going into October, November. So what happened between spring and then going into spring and summer of 2019 and then up until October, November 2019?
Okay, when I was first contracted to do the job was in March sometime of 2019. What I wasn't aware of was they had a problem with the water department. The inspector, Miss Juanita, she had got into a discussion with the homeowners there about the sewer line. It was put in illegally.
And the plaintiffs talked about that as well, and you addressed it as well. You're saying there was about a 1 month, so that puts you into maybe late May?
Yeah, I would say around May, yes.
Okay, so then let's pick up with May. So then what happened in terms of any work that was done or could be done between May and then October, November, when you're saying it starts to get too cold? So what happened then?
Okay, after we got the clearance to go ahead and put everything together, now I go down to the water department, start going through the process of pulling the permits, getting everything in order. And after we get everything in order, let me see, what was it after that? I would say we're looking at May, June, roughly around June sometime. So now we got the permits. We got everything. I have to look at their permit and see exactly what date is on it that they released it to me and gave us the clearance to go ahead and go forward.
Okay, and that's fine. We'll put a pin in that. We'll come back. So let's pick up with June and then going between June and October, November. What happened then?
Okay, during that month of June, now again, we're lining up everything to where we can get the everything working as far as with the bore, as far as with the backhoe people, which is digging the trench and all of the equipment, bringing in new sand and everything. So we're working with that at that particular moment then.
Well, let me ask you this, sir, and let's back up, sir. With regard to Bond's Plumbing, have you done projects like this before in the past?
Yes.
Okay, and how long have you been in the business of plumbing in this industry?
At that particular time, with that particular work that we're doing, I just, the year before, we did it with actually for the city of Detroit, but we wasn't pulling any permits because we had a general contractor to take care of all of that when they was replacing the lead lines, putting it in for the different various residents. So
So
I
let me
was
ask you
doing
this.
it then, but then also I was aware that right around October, November, we had to cut off because of the weather.
Right, I understand, sir, and the question is, you're saying right about June is when everything was starting to come into place, but now you're describing a period of time, and the court just wants to kind of create a timeline about what, if anything, was getting done between June and going to October, November, because you indicated based on, you know, from your industry perspective, it starts to get too cold, so, but now we're right at the height of, in June, like right in the summer.
Right.
And so the question is, you also indicated that you've been in the plumbing business for a number of years, but it sounds like only the year before you had taken on projects such as this. Is that
Exactly.
just to hear you correctly?
Right. Exactly.
Okay, and prior to this, how many projects of this had you spearheaded on your, coordinated and done on your own? Because it sounds like you're saying you've done these projects, but before it was the city or another agency or entity pretty much putting everything into place, and then you come in and do the work. So it sounds like, how many projects like this have you coordinated yourself?
To do it from start to finish, this would have been the first one. When I was doing it, putting it in with another contractor, I was the one that was hooking up the water and running the pipe, hooking up the water from the street to where the water meter is. It would be divided in different sections to where one person would do the dig, another person would hook up the water from the after the digging is done, another person would do the boring. I was the one that was hooking up the water. This was, even though, I have did it before, but this would have been the first project that I oversee everything.
Okay, all right, that's fine. Okay, so at some point, it came to where a period of time passed, so after, so starting from June and beginning to October, November, it appears that the work hadn't gotten done. So here's the thing, let me ask you this, sir, had you started any of the digging or broken ground or done any of the work between June and October, November, or what, if anything, happened then?
No, you can't, because the first thing you would have to do would be to dig inside of the street. You can't, if you don't have everything in place, then once you start digging inside of the street, then it would just be an open hole there inside of the street. And that's what I did explain to the homeowners also.
Okay, so let's move forward to the cause of, and at some point, the project, there wasn't as much progress on it as everybody would have liked at that point. So now we're getting to October, November, and now it's getting into a period of time where you and the plaintiffs are having a discussion about simply just reimbursing them their expenses. Do you agree that it turned into that discussion further down the line, like after you did break ground on the project?
Say that last part again. Do I agree that?
Okay, well, the question, sorry, let's rephrase it. At some point after you're saying October, November got too cold, so now we're past 2019, now we're getting into the year 2020. Did you eventually have a discussion with the plaintiffs about simply reimbursing them the cost of the project? Since there was not as much progress on it as everybody would have liked at that point. Is that fair to say?
Right, yeah.
Okay. So, and also the plaintiffs did indicate they were candid, Ms. Cardoza did indicate in testimony that you did pay back $2,000 of the initial down payment for the project. Is that correct?
Yes, we did work out a payment plan. Oh, we worked out something to where I would give them their money back, and I agreed to that I would give it back, give everything back. That $6,500.
Okay, okay, that's fine, and you did pay back $2,000. So, and that brings us to today overall of what's been presented, and also the court appreciates you helping to help this court develop a timeline and understanding of how these projects work from an industry perspective.
Do you dispute the basis of their claim or anything regarding the dollar amount? Because I guess that means if there's an agreement that you're going to pay it back and say, listen, this didn't pan out the way that we thought it was going to, we're not getting progress on it the way that we all wanted it to, do you dispute anything else that's to be that you agreed to pay back? Oh, sorry, that once you pay back the $2,000, what, if anything, from your perspective, do you believe that you're supposed to be paying back at this point?
You know, I have every intentions on, and I let them know of paying back the $6,500. The option was out there also, if they wanted to utilize my permit, the money that I had spent for the permit. I purchased parts also, but I let them know if they wanted to utilize the permits that I used, they was able to do that at that particular time also. The permits that I put, I think it came out to a little over $2,000. So again, I have no problem and we're paying back the $6,500. Where I would dispute them at is where they're adding extra numbers in on it to where they said I should be liable to pay back any other charges. Now that's where I would dispute at.
Well, Mr. Vaughn, and let's, that's actually, it's a good place to stop. So let the court explain that with regard to small claims, what is permissible is if a party or plaintiff is bringing a claim for work that's going to get done, and if the contract for the work doesn't get performed or isn't performed adequately, or in this case isn't performed as was intended, if it is the case that the plaintiff has to take on additional expenses in order to complete what was the intended project, it is permissible for the plaintiff to make that a part of their claim. Because but for that, the contract between you two as parties doesn't come to fruition, or the contract is not performed, if it is the case that the plaintiff has to pay out of pocket or have to pay additional expenses to get the work done that was intended, that is a permissible part of their claim. Okay? So just be aware that that is a remedy that is available in civil lawsuits, including small claims. So it is permissible. So the court appreciates your perspective from that, based on what's been presented on both sides. Just be aware that that is permitted in the small claims lawsuit. If it is the case that the plaintiff has to come out, the party has to come out of pocket additionally in order to complete the project when it doesn't get completed as intended. Okay. So the court wanted to address that before we got too far along, because it sounds like overall the court appreciates both of you, both parties, and your patience with presenting everything, and everything was beautifully presented. So first of all, thank you very much for everything being so well presented. What it brings us to then is, with testimony having been presented, be advised also one of the other things that the court wanted to present that we didn't address in the opening comments is that the burden of proof is on the plaintiff to show that there was a basis for the claim, and it's a preponderance of the evidence standard. It's not as high as a criminal case. It isn't that high. Basically, it's enough to show that, yes, there was, in this case, a contract between the parties. There's an agreed upon dollar amount and what there would be in exchange for those services, and whether or not if the contract was performed properly or performed as expected. In this case, testimony has been presented on both sides, and the court finds that it appears that ultimately it came down to the project. There wasn't performance on the project as everyone had expected or hoped for, and then ultimately it moved to a negotiation about repaying the money. At this time, based on what's been presented, Mr. Vaughn is not disputing that the project did not come to fruition as had been expected, and that he ultimately agreed to pay the money back. $2,000, both sides do agree that it was paid back. Further, enough has been presented to satisfy this court that once the project between these two parties wasn't completed as expected, the parties then had to go to another contractor and then pay again. And ultimately, the plaintiffs are not seeking the full dollar amount of what it would have cost over and above this particular project, only to the extent of the $6,500 that was paid, and then just the difference between the two for what they would have paid, and then over and above because they had to bring on another contractor to complete the work that they were looking to get done. At this time, with what has been presented,
presented, the court does find that the plaintiffs have met their burden. Court does find, on behalf of, in favor of the plaintiff in the amount of $5,999 plus their court costs. Now, the other thing too, before we depart, before we're done, if any party is dissatisfied with today's result, they have an automatic right to an appeal within 7 days of today's decision to appeal this court's decision, in which case this case would be heard de novo, meeting all over again in front of a judge. Now, it sounds like you had okay, go ahead.
Oh, I'm sorry. I understand what you just said.
Oh, no, look like you had a question, you raised your hand, so
I apologize. Someone was trying to talk to me and I was telling them not to bug me. Sorry.
That's fine. We'll take it. I thought you were, okay, that's fine. Thank you very much. Okay, again, getting back to the point. If either party is dissatisfied with today's result, they have 7 days from today's date to make their appeal. And again, because of Zoom and our technological advances, it used to be the case that you go to the second floor window of our courthouse, but in light of Zoom and our COVID protocols, please refer to the court's website. So if either party wants to make an appeal as to this court's decision, they'll be able to, the court will be able to walk you through, the website will be able to walk you through the process of effecting the appeal. Because we now have online filing options, so the likelihood is high that, again, as with an appeal, if any party wants to avail themselves of that, our website will be able to walk you through that process. Also, there should be contact information, so if you have any questions or concerns about how to do that, then folks at our small claims department will be able to walk you through any questions with regard to anything further after today. So quite in fact, you guys are in fact our very first online Zoom hearing that we've had. So forgive me if we don't have as many details available about how to do anything from here forward. So if anything, again, the court would strongly urge everyone to make use of the resources on the court's website, or use the court or the call to the court civil division if you have any additional questions about what to do after today. Okay, so here's what we're going to do. In order to make sure also, again, normally we would hand everyone hard copies of their paperwork. The court's going to complete the paperwork today and make sure that everyone receives paperwork. Again, because we're streaming online, we're not going to give full details of contact information, but for the plaintiffs, that 647 address is a good address for both of you. Is that correct?
Correct.
Okay, and then Mr. Vaughn, that 120 address is a good address for you. Is that correct?
Yes, that's correct.
Okay, great. This one, okay, that's fine. That's all we need. So again, now that we can give personal information, because, you know, if you don't want it on YouTube, don't say it here. So we're basically, yeah. So just so that's the reason why the court is just taking precautions. So we just want to make sure that everyone receives paperwork. The court's going to complete the paperwork, and again, it does include court costs. So stand by. We're just going to go through that. On behalf of the plaintiffs, the court's looking through the file. It appears that there was a $70 filing fee, $11 for mail. Were there any additional costs, again, outside of the dollar amounts with regard to the project or the contract price? Now we're just talking about court costs associated with the filing and getting the case on track. Are those the only two costs, or was there something else?
Those were the only two costs.
Okay, stand by.
thank you, everyone. At this time, we are concluded. Again, we have your mailing addresses, so we'll make sure that we get these into the mail for you, at least probably by close of business today. We're going to finalize it. Everything will be in the system. We'll get them into envelopes, and you'll be receiving copies of the paperwork today, okay? And again, please hang on to this paperwork for your records, so in case you ever need to look up anything online or do anything, filing or anything, or if you need to make any inquiries about the actual case itself, the paper that you received with the case number on it is what you're going to want to have in hand as a reference, okay?
Thank
Okay.
you.
Thank you, everyone. Take care. Good luck. Be safe, okay?
Thank you, you too.
Yes, sir. Okay, thank you, everyone. Okay. Okay, stand by. Okay, stand by, so we'll be right there. Okay. Hi, sir, can you hear us?
Yes, Your Honor.
Hi, yeah, I'm sorry, your name again, sir?
Paris Boyce.
Is it B-O-Y-C-E, last name?
Yes, Your Honor.
Okay, we're coming up on 10:30, and typically check-in time is 9:30. We typically give people 30 minutes, 1 hour to appear. It appears that the remaining files that we have are with you as the plaintiff. So sit tight, we're gonna give to about 10:30. We're just gonna do a little bit of file prep here, and then we'll be able to start taking, get you sworn in, we'll start taking testimony as to each case, okay?
That's fine, Your Honor.
Thank you, sir.
Unless it's on down in the box, so we can check.
Okay, so we're coming up on 10:30. Hi, can you hear us?
Yes, I can hear.
Okay, thank you, Mr. Boyce. Raise your right hand for me. Do you swear affirm testimony you're about to give will be the truth?
I do.
Okay, the first one that we have up is Community Business Consulting versus Shante McCool. And if you would, sir, for the record, your name and your connection to Community Business Consulting.
My name is Paris Boyce. I am the president of Community Business Consulting.
Okay, very good. And the first one we have up is Shante McCool. And it looks like as to each one, you. And again, we're in the age of Zoom in light of COVID. Let me ask you this, sir. As in this particular case, did you submit paperwork to show the basis? Oh, hang on. There's another file here.
I'm sorry, Your Honor. Let me turn off this phone.
Okay, hang on. Okay, it looks like.
Yes, we submitted. I'm sorry. Did you say did we submit the evidence?
Yes.
Oh, for Shanta McCool, we were unable to serve her.
Okay. Well, I'll tell you what, we'll set that one aside again. Well, here's the thing. If you want, you can do you have a couple of options. We can either adjourn this so that you can make arrangements for alternative service. But you want to get it done probably within the next 28 days.
You can dismiss it. You can dismiss it without prejudice.
Okay, and you can refile it when you're ready. Thank you. Okay, moving on, we have a file here for Community Business Consulting versus Ariel Johnson. And you're already sworn in, and looks like you've submitted your paperwork for the affidavit in the event of a default. You've also submitted what appears to be paperwork with regard to services for a loan, a short-term loan. And that's the primary purpose of Community Business Consulting.
I'm sorry. What you said? What's the primary business of consumer? What's the primary purpose of our business?
Yes, sir. For
Yes, we're a short-term loan business.
Okay, got it. And the court is okay. You've submitted a short-term loan application, as well as check for services, as well as contract services. All right, stand by. And service was also made by court notes. And click the also a notary fee. You want, I can
No, it won't happen. It's okay.
Okay, next up, we have community business consulting versus, looks like Shanique Tillery. And again, you're already sworn in. And you've got your paperwork filed as well as your proofs, including proofs of service, as well as documentation about the loan having been made for $342.61 special court costs, as well as your contract for the service for short-term loan for the satisfied. For Ariel Johnson. Okay, thank you, sir. Stand by. I just have to make one clarification on the Ariel Johnson case. With regards to the notary services, the court looks like the court just took the $40 notary fee. That's actually $10 per case, so just need to go back and amend that. Okay, next up is community business consulting versus Delisha Johnson.
I'm sorry, Your Honor, I could barely hear you.
The next case is community business consulting versus Delisha Johnson. We do have service. For identification, contract for service, dollar amount paid out for the loan. Court is satisfied. Okay, is that everything for today, Mr. Boyce?
That's all for us, Your Honor.
Okay, thank you. See you next time, sir. Have a good day.
Thank you.
Stay safe.